So I want to keep this very informal. If you have a question along the way, please ask it. My name's Ed Davis. I'm with the firm of Astigarraga Davis in Miami. I am an international asset recovery lawyer. That's pretty much all I do. And I want to talk to you about one of the most powerful tools that we use in international asset recovery. Although it has uses far beyond just international asset recovery, and I'm going to cover that as well. It is one of the least known and most underused weapons in your arsenal. And I know we just don't see enough of these being filed in the States. So let me take a quick poll. How many of you ever heard of 28 U.S.C. 1782? Okay, so that's good, because if we asked that question a year ago, the answer would have been a lot less hands going up. Now, how many of you have actually participated in a case in which 1782 was used? So a lot less hands, 2 hands. All right, so we've got a ways to go yet before we get to where we want to go. So let me sort of set this up for you. What if I told you that you have the ability to gather evidence for your case abroad in the United States as if you were litigating in the United States, even if your case wasn't filed yet abroad, but was reasonably complicated or contemplated? If you think I'm making that up, and I once had a lawyer tell me he thought I was making that up, that it was impossible that could happen. This statute was passed in the 1970s and really didn't start to get used until the 2000s. It was really dormant for about 30 years on the books. The only time it was used was by the U.S. government when they were processing MLAT requests. So think of this as the civil analog to mutual legal assistance treaty requests by the government, except that you don't need to use the Hague Convention. In fact, if you use the Hague Convention, you're crazy, because it is so difficult to use. It takes so long. I'll give you an example. We had a case involving Venezuela. We served our Hague Convention request. This was years ago. The case was done, finished, appeal over a 3-year period. 2 years after the appeal was over and the mandate was issued by the appellate court, the documents showed up, just unannounced in our office, in a Hague Convention request. If you were tried to use a Hague Convention request in the United States, you would not be waiting 5 years, but you would easily wait 1.5 years to 2 years for documents. With 1782, you control the process. And let me give you some very simple guidelines, and then we'll get into how you use it, because really the specifics are not as interesting as how it can be used in litigation. So let's just go through the purpose very quickly of the statute. The concept here is to give U.S. district courts the ability to help foreign litigants have an efficient means to gather evidence for their case abroad. The theory is that it would encourage foreign countries to pass similar acts so that Americans could go to those countries and get evidence. That hasn't happened. In reality, there's no, to my knowledge, and I'd love one of you to prove me wrong, there's no analog to 1782 out there in foreign countries. That doesn't mean that you don't have Norwich Pharmacal and Bankers Trust and other means, but the idea of being able to file a statutory claim for documents and able to, that comes along with the ability to get those documents in evidence back in your proceeding at home, I'm not aware of it. Anyone in Canada, John, do you guys have that in Canada? How about UK? Any statutory basis? I'm not aware of any. Anyone else? I didn't think so. It is unique in that sense. And that's probably why when we talk about it to most foreign attorneys, they frankly, in many cases, don't believe that it can work as efficiently as it does. We've filed about 50 of these around the United States. Just to give you an idea, San Diego, Northern Texas, Atlanta, many in Miami, New York City, Maine. We file them all over the place, and Chicago, and they work. Sometimes the judges haven't seen them either, and we have to walk the judge through them and convince them that this is not something that's exotic, but it's a very simple statute, and it's easy to walk a federal judge through it. So let's go through what the test is and what do you need to do, how it works. The district court of the district in which a person resides or is found. Let me stop there. In the United States, we get calls all the time saying, what is U.S. law on this point? There is no such thing. Oh, I'm sorry, I didn't press the... There it is. What is U.S. law on this point? There is no such thing as U.S. law on anything. There are 51 legal jurisdictions, 52 if you count the District of Columbia, in the borders of the United States. Each state, which is the state courts are the courts of general jurisdiction, have their own legal system and their own law. They're all common law states with the exception of Louisiana, which is a mixed common law, civil law jurisdiction. And the federal government has its own body of law. Federal government is a court of, or the federal courts are courts of limited jurisdiction the jurisdiction that was ceded to them by the states at the time of the creation of the United States and by the Judicature Act of 1789. So when you call, you have to be able to say, I have a case that needs to be filed in Alabama. What does that entail? And so it's very important that, if you heard the last panel, they were talking about comity and getting comity for an order. We recently hired a firm in Texas to pull the law on comity in Texas for an order, not a judgment, but an order. They don't have it. There's not one case in Texas that allows you to take an order, say a Mareva, and ask a court to give it comity. In Florida, we do it all the time. So it was stunning to me as a Florida lawyer to find out that Texas does not have a body of law yet on the concept of comity. This law, though, is federal law, and it's important to remember when we talk about federal law, there are districts. So in Florida, for example, we have a southern district, a middle district, and a northern district.
Does Texas recognize federal law?
Texas, barely. And we're actually in the northern district of Texas on one of these right now, so we'll let you know how things go, hopefully soon. And the court may order the person to give testimony or statement or to produce a document or other thing for use in a proceeding in a foreign or international tribunal. I'm going to parse all of that out over the next few slides, and it includes criminal investigations. So for those of you who are in civil law countries and you're in the midst of doing a plain penal or a Strafenzeige or a querella or denuncia, you can use 1782 to obtain evidence and then give it to the prosecutor or give it to the judge when you are prosecuting this. So how does this work in an international asset recovery case? You're handling a case, it has a multi-jurisdictional piece to it that's in Switzerland. You need to bring it up to Swiss counsel that you can get evidence in the United States if you need it so that you can help the Swiss prosecution. And the Swiss lawyer will say that's impossible, and you'll say, no, it's not, 1782, and I'll send you this PowerPoint if you want it, and you can show it to him or her. The key here is the order may be made pursuant to a letter rogatory issued or request made by a foreign or international tribunal, or, and this is the key part here, the first part I just read is all government, forget that, or upon the application of any interested person. That's critical because what is an interested person? I'm going to cover that in just a moment. That's the clause that we use to bring these 1782s. As an interested person, a litigant is an interested person, and others, and I'll cover that in a moment. So that's the test. That's it. That's all you have to do in order to bring a 1782. You have to be an interested person, and you have to have a foreign tribunal. So what are the requirements? And when you're pleading this, we plead these things as if it is the British standard of full and frank disclosure. We're not required. We don't have full and frank disclosure in the United States. That I'm aware of in any state or at the federal level. We do have a duty of candor to the tribunal, but we don't have full and frank disclosure, which requires us to disclose adverse facts. We don't have to do that. Now, we take the position that we're much better off doing that and walking the judge through it because this is an ex parte application. So we don't want the judge to think that we're trying to pull a fast one on the court, so we go above and beyond. And I will tell you, I've had clients when we file these say, do we really have to put that in the affidavit? That's not helpful to us. And my feeling is we should cover our bases because when the other side comes in and tries to challenge it down the road, we can say, Judge, that was all there. It was all in the affidavit, and we were full and frank all along.
Would you ever do it on notice?
Sometimes, no. Generally, if I don't have to, I don't. But sometimes judges require you to do it on notice. Even though the law is clear that it could be done ex parte, we've had judges call us and say, I'm not comfortable doing this on an ex parte basis, so please notify the other side. The one case we did it on notice was with our colleague Martin. We served discovery on a law firm. We asked for discovery on a 1782 to be served on a law firm. And we wanted to put them on notice because this was going to be asking for privileged material. And we were making the argument that it was subject to the crime fraud exception. And therefore, we wanted to have that fight right up front, and that we weren't trying to sneak around and gather this information. We didn't think a law firm was going to produce it without a fight anyway. So we might as well take the high road and let the judge know right up front, and bring them in and let them know what's going on. And that's the one time that we actually did it on notice, purposefully on notice. So you have to make a request. As I said, it can be by the foreign tribunal or the interested person. The request must seek evidence, whether it be testimony or a statement, or production of a document. The difference between testimony and a statement is testimony is typically in a deposition where the other side is present and they can be cross-examined, whereas a statement is under oath and you ask it under oath, but there's no other side to question. Obviously, you can be governed by how useful that is in your own proceeding. The whole idea is to make this a flexible proceeding that allows you to gather evidence the way you need it so you can use it in your proceeding as best as possible. The evidence must be for use in a proceeding or in a foreign or international tribunal. We'll come on to that in just a second. And the person from whom discovery is sought must reside or be found in the district. This is important because you have to go, if there's different pieces that are located in different districts, you have to go to each district and file a couple of different ones of these. They're relatively simple, relatively cheap if they're not opposed. And we filed several. In one case, we filed 3 in several different jurisdictions, which were because the person lived in the district in Louisiana, the person lived in the district in Florida, and the person lived in the district in Atlanta. So we had to file 3 separate ones. The lead case, sort of the mother of all cases in this area, is the U.S. Supreme Court case Intel. And the Intel court defined an interested person as encompassing more than just a litigant in a foreign proceeding. And the court didn't really go to try to define it too narrowly, but it was very important because up until that point, the argument had been that if you're not a litigant, you're not an interested person. Well, that's not true. You could be an intervenor. You could be an insolvency practitioner. You could be theoretically an expert witness and bring a claim because you're involved in a tribunal and you need information in the United States to assist you to discharge your duties as an expert witness. So there are lots of different bases that can be used to argue that you're an interested person. In fact, I think that we're only limited by our own creativity in that regard. Obviously, I'm not suggesting we take this to the absurd. For example, a reporter could not come in and say, I'm an interested person because I'm interested in that case and I want to file a 1782. That's not going to work. You have to be involved before the tribunal or about to be involved before the tribunal. And if you see the test they gave, is someone who has a role in submitting evidence and has participation rights in the foreign tribunal. So I'll give you an example. If an heir in a proceeding in a foreign country, in a probate proceeding, but they're not before the court, wants information to challenge the will, you could use this proceeding to gather. And we've done that for Brazilian heirs who are fighting, they say, or alleged improper conduct in probate courts in Brazil. What constitutes evidence? Anything you can think of. Documents, contracts, emails, Google searches, WhatsApp, as long as it's saved, blood samples, hair samples, if you needed it, anything like that can be gathered. Any evidence you can get under the rules of civil procedure, you can get under 1782. There's simply no limit to the scope of the evidence that you could get. Now,
defined by which jurisdiction? Your local jurisdiction or the U.S.?
No, this one is defined by the federal rule of civil procedure, which is Rule 26. And that's an interesting issue and a perfect segue. If you've ever heard me speak about discovery in the United States before, I've talked about the test is reasonably calculated to lead to admissible evidence, which is a hole you could drive a truck through, right? Reasonably calculated to lead to admissible evidence. That was the test up until recently. As of December 1st this year, the test is changing. And it's interesting because, and I think this is being driven largely by a sense that U.S. discovery is too broad and the cost of complying with it, as well as the cost of complying with e-discovery, is really becoming so burdensome that it's killing litigation. So the new test, starting in a few days, is that the discovery must be, quote, proportional to the needs of the case, considering the importance of the issues at stake in the action, the amount in controversy, the parties' relative access to relevant information, the parties' resources, the importance of the discovery in resolving the issues, and whether the burden or expense of the proposed discovery outweighs its likely benefit. Information within this scope of discovery need not be admissible in evidence to be discoverable. So they left a little bit of the reasonably calculated to lead to admissible evidence, because sometimes you can get information or evidence that's not necessarily admissible in your proceeding, but it might lead you to a piece. But that test is a much more nuanced test that really looks at the cost and balancing. So if you walk in now and ask for the typical U.S. broad discovery, give me all documents on these topics that are in your possession, I think you're going to get pushback, number one. And number two, there's a basis for pushback, and the court's probably going to whittle down your request. Now, we're still not anywhere near this idea that you have to have a rifle shot, that you have to identify the specific document, the contract dated XYZ, and between these two parties. We're not at that level. I don't think we're ever going to get to that level in the United States. There is a reasonable penumbra around your request that a court will allow you to push the envelope a little bit. Because the idea is, under our system, get as much information out as you can and let things sort themselves out in front of the court within reason. So I do think that this is I think, frankly, this is good for asset recovery lawyers. And I'll tell you why. Typically, when you go up against money defendants, the victim has very few documents. What documents does the victim usually have? Almost nothing. It's the bad guys that have all the documents. So I'm not worried about this affecting us as asset recovery lawyers, this change. I think they may try to use it to hone down some of our requests, but at the end of the day, I think that this actually works. As long as we're staying within the bounds of proportionality, it's going to be fine, and the test isn't really going to, I don't think, affect us meaningfully. Depositions. How many people here know what a deposition is? Okay. For those that don't, a deposition is a proceeding whereby a witness is summoned in under court power, sat down in a conference room in front of a court reporter, and you can ask them questions in federal court for up to 6 hours. Any question that's relevant. And they have to answer, or they'll go in front of the judge and explain why they won't answer. You cannot compel them to give up privileged information. And there's a list of privileges. Attorney-client privilege is the most commonly talked about, but there's a husband-wife privilege, and there are many other. There's the priest-penitent privilege and others that you can't force people to testify about. But short of that, they have to sit down and give evidence. And you can do it in front of a videographer, and I recommend that, especially if you're never going to get a shot at this witness again. You can put those video clips or the whole video in front of your arbitrator or judge back in the home country, and it's super powerful evidence. It's really fun, and I've done it, to be able to ask a person a question, have them lie on the stand, and then press the button and have them and impeach them with not only the words on the paper, but the video clip. It is just a fun thing. It's so powerful, and it's just watching their face, watching the judge look at them and the jury look at them is like, I'll never believe another word this guy or gal says, because we've just impeached them with the tape. It is a beautiful thing when it works. Depositions are allowed. It's now beyond doubt. In a case we recently had involving Canada, actually, in which we represented the Mesa Group, we were able to obtain a ruling that allowed us to take depositions. That was really not in doubt. It was just one of those obvious things that a court hadn't ruled on, and the other side took a shot at trying to block depositions, and we were able to get a ruling that said depositions are clearly within the context of 1782. In another case we handled, though, in the Pinchuk case, we were on the other side. Actually, it's one of the few cases we've ever defended a 1782. There's only two in our firm's history. And we blocked it on the basis that we made an argument. We made a promise to the court that we would produce that witness in the arbitration proceedings. This way, we alleviated any concern that the witness would be unavailable. And so, kind of a dirty trick, I guess, in some ways, but we ultimately won. And the other side did not get to take the deposition of the witness that they wanted to. The practice tip, and I'll come on to this in just a second, is to take your depos before you file if you can. Take your 1782 shot so they can't make that argument against you, because there's no one there at the other side to really block you and say, to offer, well, Judge, you don't need to do this because we're going to make them available, and that sort of steals your thunder. So that's a practical tip that I would give you and we'll talk to you in just a second about how you do that in a 1782 context. this is a fun one. This is a new development, relatively new development. What about getting evidence outside of the United States by using 1782? And here's what I mean. If a company in the United States under our system, under the federal system, has information in its possession, custody, or control, it has to produce it. So I'll give you an example. Subpoena is served on a bank branch in Miami for an Ecuadorian bank. The Ecuadorian bank is not subject to the court's jurisdiction, but its branch is, or its affiliate is, and the affiliate testifies that it can pull up copies of the account statements on its computer in Miami. The court ruled that's within your possession, custody, and control. Print it out and produce it. You have it. You can't pretend like you don't. You testified that you do. So now you have the information you would otherwise never be able to get in Ecuador, but you got it through sort of what I call a bank shot or a ricochet in the United States by using this. Another one that could work is where the documents, the physical documents, are in another country where you just can't get discovery. And so you're not talking about electronic information, you're talking about physical documents. But if the company has the ability to call up its affiliate and ask for it to be produced because it's within its possession, custody, or control, and there's a whole body of law on what possession, custody, and control means, you can force a U.S. company to produce that information in the United States, even though it's residing in France, for example, or residing in another jurisdiction. To me, that's a very powerful use of 1782. I have my concerns that if we abuse this, it's going to get cut back on us. We have to be careful about going too far with it. But, I mean, the world is shrinking, and I think possession, custody, and control has to mean something. Yeah?
So the judge can actually make a positive order that you have to call the other office and get the information, or is it more posted on an interest or?
If you have testimony from somebody that says we have routinely access to that information and we get it all the time, and that's the key, the setup, the factual setup is we get that, if we want it, we just get the information from our office anytime we want. And you can usually trick a witness into that, frankly, and say, well, you know, what about this? Would this information be useful to you in your job? Yes, it would. Well, how do you get it? Well, we called Joe, and then Joe sent it to me. Okay, so you can get Joe to call, oh yeah, Joe, I call Joe all the time. And then later, now they've produced this low-level witness who says he gets the information all the time. When the company tries to row back from that, which they do, you say, well, Pete said he can get it from Joe anytime he wants. So
that overcomes them arguing, oh, that's a separately incorporated separate unit, which makes its all the decisions, doesn't it, to the public?
That's the intent.
Let's start with that admission.
That's the intent. Now, when you get to banking, one of the arguments is, if I produce that information from Ecuador, I'm actually in violation of Ecuadorian law. The judge in Miami said, that's your problem. If you don't like that, then don't have a branch in Miami. That's not a problem. That's not my problem. You decided to come here and take advantage of our banking system, and you opened your branch here, and you have access to that information. You have to produce it. That's the way it works. You're not going to be able to hide behind that curtain. But that's what it's intended to get around. There isn't, I will give you one warning. The Supreme Court has been dialing back the extraterritorial application of American laws over the past several years. They've dialed back the use of the Alien Torts Claim Act, that it cannot be applied in an extraterritorial manner. It's the Alien Torts Claim Act, but the idea is that's usually dealt with torture abroad and things along those lines. So this Supreme Court, in a 5-4 vote, and the conservative side of the court dialed that back. Then they dialed back the use of American securities laws, the 33 Act and the 34 Act, on extraterritorial application. Just a couple weeks ago, they took a case involving the extraterritorial application of RICO. That's very scary because that's a powerful tool we use, which is the Racketeering Influence Corrupt Organizations Act. There's both a state-level act and a federal act. And in the Supreme Court, my concern is this court will try to dial that back and not allow it to be applied on an extraterritorial application. And usually you can, up until recently, you could say whether if there was conduct in the United States or an effect in the United States, you could use these acts. So if you build, I don't want to use this example under the current circumstances, but if you were to be in a circumstance where an act was performed, you designed a fraud in Venezuela and you perpetrated it on Florida residents, but all of the actions were done in Venezuela. The phone calls were made in Venezuela, the materials were produced in Venezuela, the money was sent from the United States to Venezuela, would you be able to prosecute that in the United States because the victims are in the United States? There's an open question now, I think, about whether or not that is enough, whether that the effect in the United States is enough, because the conduct wasn't in the United States. The conduct was, now, there'll be arguments that you use the phone lines and you use the wires, but I'm telling you now, it may be an unintended consequence of what the court is doing, which is to try to pull back American jurisprudence and jurisdiction for whatever xenophobic reason they have. But I'm telling you that my concern is that RICO will be dialed back, and there's a possibility they'll look at 1782 eventually as well, which is really going to be interesting because the whole purpose of the act is to provide for discovery in foreign jurisdictions. I don't see how they could do it without gutting the act. One issue there's been a lot of litigation on is what is a foreign tribunal? I'm not going to spend too much time on this because this is largely dealing with issues of arbitration and whether a private arbitration is a foreign tribunal. The law is trending away from recognizing a private arbitration as a foreign tribunal. Why would I bring that up in an asset recovery context? Because more and more these large infrastructure contracts that are procured through fraud and corruption have arbitration provisions in them. And the bad guys are going to try to rely on those arbitration provisions, the putative bad guys, if you will. And so we have to be aware that you're not going to be able to use 1782 in an arbitration context. Almost every other tribunal where the tribunal has the ability to make decisions is going to qualify as a tribunal for the purposes of using 1782. I'm not overly concerned about it. Unless you're in arbitration, this doesn't usually come up. So I'm going to skip over that and move on. There's a whole raft of cases on what a foreign tribunal is, and they're all involving arbitration. It has to be for use in a foreign proceeding. One of the defenses people bring up is, and we faced this in a case out of Brazil, it's not relevant in Brazil. It'll never come into evidence in Brazil. That was the other side, and they put in an affidavit from a professor from a law school in Brazil saying, you'll never get this into evidence. And our judge said, rightfully both under the statute, the words of the statute, and under the case law, that's not going to be one of the considerations this court takes on board. We don't care if it's relevant, because that's not our standard. What happens in your tribunal about whether it comes into evidence or not is going to be between you and your judge down there. It's not going to be relevant to me. As long as the information, I'm comfortable that it's relevant under our standard, I'm going to allow them to get it. And that's exactly, almost words right out of her mouth. And we ultimately use it. Of course, we were able to use it in Brazil. The judge was quite interested to see this information, which the other side said did not exist. And we were able to show that it did. So it is powerful when you can walk in and show the judge information the other side said doesn't exist, as you can imagine. And they were trying to hide behind the curtain, if you will, of the national boundaries. So for use in a foreign proceeding is critical. Who is a proper target? As I said, the target has to be in the district. You cannot serve discovery. The one restriction is this is third-party discovery. So you can't, if it's X versus Y, you cannot serve discovery on Y. But you can serve discovery on Y's subsidiary, Y's affiliate, and officers or individual employees of Y if they live in the district. But you can't serve it on Y because that's between you and whatever court or tribunal is adjudicating the dispute between X and Y. That's the one restriction that you have to be aware of. You do not have a requirement to exhaust your remedies to obtain discovery from the foreign tribunal. You don't have to go there first and try to get it and not get it. In fact, I would counsel you not to do that. That would be a huge mistake because you create the possibility that the judge will say, no, I don't want you to get that discovery. And that is one restriction, that is one of the discretionary things that a judge is allowed to take on board when deciding whether to grant a 1782 application and to issue the subpoena. She has to think about that issue. If there's competent evidence before the court that the foreign tribunal either has ruled already that it does not want that discovery or would generally not consider it, not that it's irrelevant, but the court has made an affirmative statement that the court's not going to consider that evidence, then typically the United States courts will not grant the 1782. So you would really muddy the water up by going in and asking your court in your foreign country first for permission. This is one of those where you do it and ask for forgiveness after the fact. You don't ask for permission up front, I would recommend, unless you absolutely feel you have to. These are filed ex parte. As I said earlier, they're done ex parte. It's usually we get the order back in a couple of days, a few weeks. Only one, and it's a particular judge in Miami, she's slow on everything. She took 6 months to rule on it. That's the outlier. So I get questions, how long will it take? Well, if you take that one outlier and throw it out, we're looking at something between a week and 2 to 3 weeks to get the order back from the court. And a lot of them, we get them back in one day. We file it on a Monday, the order comes on a Tuesday.
Are these done under seal?
They can be. In fact, we just filed one in Texas. We asked the court to put it under seal, and we asked the court to gag it so that the target doesn't know that we're getting the information. But that's dicey. I know Martin Kenny has gotten one out of San Diego, a federal judge in San Diego, where he got a gag and a seal. So we've gotten gags and seals in Chapter 15 proceedings where we're using 2004 examinations and subpoenas out of bankruptcy court. That's easier because the bankruptcy judge gets it. The bankruptcy judge understands you kind of got to creep up on people because they deal with that slice of the world every day. Federal judge doesn't deal with that on a daily basis. So he or she is really thinking, wow, you want me to seal this and you want me to gag it so that the person whose bank account that you're getting doesn't know until 20 days later that you've taken copies of their bank account statements? That's a big ask. They see it as a big ask. And so you've really got to lay the predicate, the record for why you need that. And so you've got to show that they've been dodging and weaving and cutting and running and not producing information in order to lay the predicate to get a gag and a seal in the States. It's not that easy. But you can. I mean, there's nothing that stops you. There's nothing in the statute that prevents that from happening. Discretionary factors, as I said, I'm not going to spend a lot of time on this. I just want you to know there are discretionary factors that the court can consider with regard to whether or not the court grants the 1782. The court's allowed to look at the nature of the foreign tribunal. You heard the comment here earlier about Ukraine. Well, there are issues that come up. In reality, if you are seeking information for use in a foreign proceeding, one of the things that when you walk into a federal district judge in Atlanta or North Carolina and you're asking for documents for a foreign proceeding in the Ukraine, I mean, I hate to say this, but half of them probably don't know where the Ukraine is. So please, I hope this is being recorded because I'm sure there's some federal judges that wouldn't take kindly to that. But the truth of the matter is, Americans, as a general rule, are geographically challenged people, and so what happens is, I think that there's a presumption that arises in their minds. Well, these aren't real courts. Or they hear all the horror stories about, these are sort of kangaroo courts. So you have to lay the predicate that this is what you're asking for is for a proceeding that is before a legitimate court, and lay it all out there in your affidavit. Don't, because the way you do this is it's a very short application, a couple of pages that lays out the bases, and then an affidavit that specifically identifies why you're asking for it, what court you're before, or what court you intend to be before, and then what the purpose of the information what you'll use it for. That's got to be in your affidavit.
Is there a comeback where the other side can try and set it aside?
Yes, typically the way that, unless there's a gag, which is rare, typically the way it happens, if it's going to happen at all, is the target gets the subpoena. Target notifies the other side. The other side then moves to intervene, which is the low standard to intervene. The court always grants it, should. And then the other side gets to come in and make an argument that this information, they make all the arguments we talked about already. It's, not something that's relevant. It's never going to come in, blah, blah, blah. They go through, all of the song and dance. And typically that's done without an evidentiary hearing. And it's done before the court and usually very quickly. And we've been able to, in almost every case, except for one that stands out in my mind, overcome all of the objections that are brought up at that point. Amazingly, I'd say about a third of them, nobody ever objects. And the documents are produced, and we package them up, and we ship them off to our client, which is usually a lawyer in another country, And we never hear about it again. The information goes into evidence. We had one for a law firm in London where we got 40,000 pages of documents from an entity that had done business with the other side. And it took quite a bit to get all these pages pulled together. They knew we were doing it. They became aware of it at some point. We produced it, and I'm told that it led to a $400 million resolution of the case. And the entire cost for the 1782, with the documents being produced and everything, was about $48,000. And in the context of and that was everything. The only reason it was so high was because there was 40,000 pages of documents that had to all be brought in, scanned, and sent out. And that was probably the biggest expense in the entire proceeding. They never showed up to defend it. So I'm not going to go through these discretionary factors too much. I want to talk just for a second. As I said before, the court may deny discovery if the foreign tribunal is expressly unreceptive. We get all the time the defense, they're not going to entertain this. It has to be express. There has to be a affirmative statement from a judge saying, I'm prohibiting you from doing this, or if I get it, I'm not going to consider it. Now, what judge is going to do that? What judge is going to do? Even with that, the federal judge can override that. It's only a discretionary factor. And I have to believe that about, I would say a good chunk of our federal judges, if they see something, they understand it, they usually say, counsel, tell me what this is about. Tell me why you need it. Walk me through how this is going to be relevant. And if you make a good, cogent presentation and it's clearly relevant, and the other side stands up and says, here's something from our judge in Guatemala that says she won't take it, I think a good chunk of our judges will say, well, I'm producing it anyway. I'm not sure why a judge would say that when a document is absolutely relevant. There's no doubt it's relevant. So I'm going to produce it, and then you guys do with it as you wish, but I'm going to let that go because I think the perception could be it's a rigged game. So a federal judge can override it because it's merely a discretionary factor. Burden, as I said, cannot be unreasonable, duplicative, or obtainable from some other source that is more convenient, less burdensome, or less expensive. That is part of our discovery test. This doesn't come up that much except on the unreasonable part. If it's truly duplicative, if they've already produced it in the foreign proceeding, you have no chance of winning in the 1782. You've wasted everyone's time and money. So I can't imagine if that would have come up by now before the time the other side can object. So I can't imagine that's an issue. Convenience and burdensomeness and expensiveness, you can usually deal with that by saying, we'll pay for it, Judge. We'll pay for the costs. Not an issue. And we almost always offer to do that. Not an issue to... It's not an issue. You can't usually block discovery just because it's expensive. I will say, though, that the new rules suggest that that's going to be a new factor that we're going to have to keep in mind. I don't think we're going to be able to just ignore that as much as we did before. The types of cases we've used it in, every one of the cases I'm citing are cases that my firm has filed and taken all the way to the end. Breach of contract case, in the consortial case, which is really now the leading case, in the 11th Circuit on 1782. We've used it many times in arbitration. It is as I said, that's one of the ones where we were able to block it. This comes up a lot. I will say, though, that over the past 8-9 years, the courts have slowly moved away from private international arbitration. And unless there is a change in the statute, I think the Supreme Court's going to ultimately say was not intended for that. Now, what we're trying to do in Florida is pass a separate statute called the Mini 1782 statute, which would allow you to come to Florida and ask, and we're specifically going to put in it that private international arbitration is included in the definition. So stand by for that. We have a committee in the international law section, and we're proposing that Mini 1782 on a state level be created. And then if that takes, we're going to try to push that out to some of the other states and open up that avenue. Fraud cases, we've used it. In the In re Braga case, that was a particularly interesting one. I'll just take a minute on the facts on that case. And actually, Dan back there worked on that case with us. The interesting issue there was the other side in Brazil had told the judge that the principal was not the owner of this particular company, actually two companies. And so the judge said, okay, fine. Then you produce to me the names of the ultimate beneficial owners of the Cayman companies that owned these two companies, these two Brazilian companies. So it was two Brazilian companies owned by two Caymanian companies. And they were like, I'm sure that when they walked out of there, they were like, not a problem, Judge, not a problem. I'm sure when they walked out in the hall, they were like, holy cow, what do we do now? Because the ultimate beneficial owner was that lady. There's no doubt about it. The documents were clear. So what they did was they hired a Miami lawyer to put together, and that Miami lawyer was flown down, and we got the documents showing his flight itinerary. We got his expense reports. He was flown to Brazil. He reads fluent Portuguese. He admitted under oath that he got a copy of the court's order and that he flew back to Miami and that he was engaged by the client after that. What happened next was they formed two Costa Rican corporations, and the two Costa Rican corporations became the owner of the Brazilian companies, which were then in turn owned by the Caymanian companies. And the two principals of the Costa Rican companies, one was a woman who owned a laundromat, and one was a retired engineer. I don't know how they picked these people, but they were almost like what you saw earlier today with regard to showing the folks from Moldova, these people who were, nominal owners. So they went back to court and they said, Judge, as we promised you, here's the ultimate beneficial owners of these companies, and it's the laundromat lady and it's the retired engineer, and they're both in Costa Rica. See, we told you we're not the owner. This woman is not the owner. She's a very famous, powerful woman who was very rich and owned a bank. So we knew this was false, so we had to figure out what to do. So Dan's firm led the charge and ultimately obtained information from Costa Rica using investigators and a lawyer down there to get copies of the information involving the formation of the Costa Rican companies, and it all pointed to Miami. Everything kept pointing to Miami. So we served the 1782 on the law firm in Miami and on several others, and huge fight about attorney-client privilege. But everybody overstates what is covered by attorney-client privilege. Just because you take a document and hand it to your client, or your client generates the document, or a document gets sent or received by a lawyer, does not make it attorney-client privilege. It has to be obtained or sent in the furtherance of rendering legal advice. And it cannot be a document that was out in the public domain. So a document that comes from the registrar in Cayman, because it was seen by other people, cannot be privileged, ever. So we had him produce all the documents he got from Cayman, all the documents he got from Costa Rica, and all the things he sent to Costa Rica. Anything between him and the client, which frankly there probably wasn't much, was not allowed. So we couldn't get his phone records, we couldn't get his notes from phone conversations, and we couldn't get any letters he wrote to the client. But everything he wrote to third parties, we got it all. And it showed that in a 10-day period, he was a busy beaver, and he went and got these Costa Rican corporations set up, and he worked with the company in Cayman, the incorporation agent, and got this all changed around. By getting that, we took that information back to Brazil, and were able to show that they lied to the court, that they fabricated this evidence, and it was pretty much ball game at that point, and we ultimately got the ruling that we wanted. That's the power of 1782. It is absolutely powerful. They were walking in saying something doesn't exist, and we were able to show that it did. Fortunately, they used a Miami attorney, or else 1782 would not have been able to be used. In practice, one of the issues, one of the cases that I wanted to just mention, because it is the case that has generated more 1782s than any other case, and that's the Exxon versus the Chevron versus Ecuadorian plaintiff's case. How many of you are familiar with that case? In fact, the judgment entered in Ecuador was just deemed to be adjudicated as a valid judgment in Canada, right, John? And Link, Maureen, that's a big case on a judgment enforcement case. And the court didn't go all the way, but it went pretty far, and it found that the judgment could be domesticated in Canada. But as part and parcel of that, there was a whole bunch of conduct by lawyers in the United States, allegedly, to machinate a ruling in Ecuador, including producing a documentary. And that documentary had outtakes. It took stuff out that wasn't helpful to their case. And ultimately, a 1782 was served with a subpoena to get copies of all the outtakes, all the information that they generated, all of the communications back and forth between the experts and the lawyers, because the lawyer hired the expert to be used in Ecuador. There were allegations that bribes were paid to judges, so copies of the lawyer's trust accounts and all of their bank account information was produced. I've lost count. I don't know if it's 10 or 12 1782s. It's filed by both sides. Both sides came and just were going at it. It was a real shooting war with regard to 1782s. And the power of it was all this stuff came to light. Everything bubbled up, and it got to be resolved by the court, or will be resolved by the court. And even if the Ecuadorian court stubbornly refuses to revisit its judgment, at least it's out there. At least the public knows about it. I mean, everybody knows that something stinks, or allegedly something stinks with regard to this because of all this information that came out. So I think that you just need to know there's so many of these Chevron 1782s. I'm not going to cover each one of them, but it was just a epic battle involving legitimate Ecuadorian victims. That's the shame of this. The victims in Ecuador, their lands were arguably destroyed and not returned to the pristine state they should have been returned to when the oil company pulled out. That's the dispute. And they inherited this sort of bubbling pits of tar and oil in the jungle. And they were bringing this claim, these 48 Ecuadorians, to say, look, you got to come back here and you got to fix all this. So what gets lost in the story about all this fraud and back and forth is that there are legitimate victims here. And Chevron will tell you, I'm sure if their general counsel was sitting here, they're a legitimate victim too of this, and they ultimately claim that they were the victim of a judgment that was procured through fraud. So I do believe that 1782 has shed a lot of light in this. Now I've got two more points I want to cover, and then that's it before drinks. So this one is probably the most important one, especially from a fraud or an anti-fraud or asset recovery lawyer. You are allowed to bring a 1782 to assist you in procuring evidence for a reasonably contemplated action. That is an action you haven't brought yet. If you forget everything else from this, don't forget this. That if you're contemplating an action and there's evidence that's critical to that claim, and it's in the United States, and you're not time barred, and you have a legitimate cause of action, and you can put in your affidavit, these are the actions I propose to use it for, here's what I'm going to do with the information, here's what I want, but I need this information in order to bring my claim, or to make sure that my claim isn't barred, then the court is generally going to give that to you. And we've done this numerous times before we file the action. Partly because the likelihood of the other party jumping in at that point, how is the other party going to have a legitimate basis to intervene? They haven't been sued yet. So at that point, the only party that can be heard would be the discovery target, and usually the discovery target doesn't have a dog in that fight. They don't care. It's just documents they have. It's a bank. They're like, here are the documents. We don't care. Just don't make us spend any more money than we have to spend, and they'll hand you the records. So doing your discovery using 1782 before you ultimately bring the claim is super powerful. Now, you have to be careful. I think this is the one area that's most susceptible to abuse, and it's the one that if we're not careful, we're going to kill the golden goose, because this will lay eggs for us, for golden eggs for years if we don't destroy it. In a couple of cases, courts have sought to define what it means to be reasonably contemplated. And there are a couple of instances in New York recently where courts declined to give 1782s and issue the subpoena because they felt that the action was not reasonably contemplated. It was a true fishing expedition. And in fact, one of our courts even used the phrase fishing expedition. And one of the courts, she defined this as, in her ruling, referring specifically to whether it was reasonably contemplated that Jiangsu would bring a claim. She wrote, as regards the latter, the request for discovery in aid of the enforcement of an arbitration award seems unreasonably premature, to put it mildly. Indeed, insofar as enforcement is concerned, Jiangsu's effort to identify, quote, a reasonably, close quote, contemplated procedure differs not a whit from a scenario in which I, quote, reasonably contemplate, quote, buying a new car because I might win the lottery if I decide to buy a ticket on my way to work tomorrow morning. I might indeed contemplate buying a car with my winnings should I actually obtain them, but my contemplation is not reasonable until I have some money with which to purchase the car. So she really set the standard, and I think that Jiangsu was definitely overreaching in trying to get this discovery. In another case called In Re Asia Maritime Pacific Limited, the court found that there was an outright fishing expedition and they were attempting to abuse 1782. The court said at a minimum a 1782 application must present the district court some concrete basis from which it can determine that the contemplated proceeding is more than just a twinkle in counsel's eye. So we have to be very careful how we use this. I'm very concerned that if we overstate it, it's going to come back to haunt us and we're going to lose the ability to bring these claims. Lastly, this is the newest development of all, and that is in the Glock v. Glock case. This is the person who invented the Glock line of handguns, who's getting divorced in Austria, which is interesting that they chose to use litigation and not handguns to solve their problems with each other. I'm happy to see that. And the court made the 11th Circuit Court of Appeal, which covers Florida, Georgia, and Alabama, which is my circuit, the 11th Circuit, made an interesting ruling because in the context of the 1782, information was obtained to be used in Austria because an allegation was made that information existed that should have been produced and that showed the net worth of Mr. Glock. And Mrs. Glock was arguing, you've got other assets and you're not disclosing them to the court. So she then went back to Austria with that information, and then she wanted to use that information in the United States on litigation. And Mr. Glock said, you can't do that because the purpose of 1782 is to procure information for a reasonably contemplated action outside of the United States, not inside the United States. And the 11th Circuit said that's form over substance. Once you've used it or you did it properly, if you legitimately sought it for the foreign proceeding, but it has a secondary use in the United States, we don't see a problem. There's nothing in the statute that says you can't do that. We're going to allow you to use that information in actions in the United States that are related somehow to the underlying claim that you would have brought or that you did bring in the foreign proceeding. So I think that's a great development. It could also lead to abuse. I mean, you could do the old boomerang or ricochet here as well because you're really trying to get information because you really want to use it in the United States, but you make up that you're going to bring a reasonably contemplated claim abroad, and then you don't, or if you bring it, it's a weak claim just to give you a pretext to bring the 1782. I think you have to be careful that we don't overstate this. And in this context, there have been some arguments that, look, Judge, they told you they were going to file a claim. We objected. 5 months have gone by. We're still having a hearing on this objection, and they still haven't filed the foreign claim. That shows you it was not a legitimate, reasonably contemplated claim. And the court said the passage of time, 4 courts now, 3 courts have said the mere passage of time is not enough to undermine whether or not it is a reasonably contemplated claim. You have to show me more than just the fact that time went by. Because the reality is I haven't given the documents yet because you're objecting. So how could they file the claim? You can't very well hold that against them. So understand, I think, now that it's fair game to use documents that we obtain in the United States for foreign proceedings in the United States down the road, and just keep that in the back of your minds for possible use. So let me open it up for questions. I think you heard the applause over there. That means that they're done, and we wouldn't want them to get more than their fair share of alcohol. So I am open for questions. I'll be here for the next day, and I'm happy to answer questions. And I'm happy to give you this PowerPoint if you want it, if you want me to send it to you. Dan?
Do you have to pay compliance costs to the respondent producing material?
No. What you have, if it's expensive, if it's nothing more than just a few copies that they have to produce, if that's the case, in many cases it is, then there's no issue usually. But if it's a massive production, like in the case of the 40,000 documents that we got for a London law firm, we had to offer to pay it, and we did happily pay it. And you do have to, we offer it just to take the expense issue out of the equation. You're welcome. You don't have to pay the other side's. Let me be clear. When we say costs in the United States, we mean costs, out-of-pocket costs. We don't mean fees. I know here, when you talk about costs, you're talking about fees. You don't have to pay the other side's fees, and typically the bank or the target doesn't really have fees. They usually don't, as I said, have a dog in the fight, so we don't have to pay their fees. But if they have legitimate out-of-pocket costs for compliance, because they have to go to a warehouse and pull boxes and produce copies, that we pay for, but not fees. Yes?
You spoke about the relevance of documents and how that brings back to that the judge would look at necessarily. How will that fit in with it being all about proportionality? Because it would seem to me that
It's a fair point. I think that the mere fact, though, where this comes up is the other side says it's irrelevant in our case. And our judges are going to, they're two separate questions, because our judge will typically say, look, whether it's irrelevant or not is going to force me to make a determination, understand the underlying case, understand foreign law, and then try to figure out, have a battle of the experts as to whether this is relevant or not. I'm not going to do that. I'm just going to allow the documents to be produced. And if you can't get them into evidence, that's your problem. And if you can, that's their problem. But in the process of getting along the way there, if there's a proportionality issue, I think that's where the relevance creeps in, because our judges aren't, I mean, they're pretty smart folks, and if it's a tangential request or something that's kind of far afield and the cost is high, I think that you're more likely to see a judge say, I'm not buying it, I'm not giving you this discovery. So I do think that it's going to creep into the consciousness now of a determination of whether or not it's relevant abroad. Sorry about that. Keep doing that. Other questions? Comments? Use it. It's very powerful. We want you to use 1782. The doors are open in the United States. We're open for business, and it would be great to see more of these filed. I just think that the more we get filed, the more we're going to have a defined body of law, and it'd be very, very nice to see this body of law get rounded out such that this becomes the even greater tool than it already is. So thank you very much for your time.